Okay, shall we make a start? For those of you who don't know me, my name is Sarah Davisworth. I'm a partner at Forbes Solicitors. I work in the insurance department based in Leeds. I do a mixture of casualty injury work and disrepair work. I have to say, and that's one of the topics that we're going to discuss today. Certainly in the last few years, disrepair has started to dominate my caseload. I've actually been at Forbes. This is my anniversary month, so it's 21 years this month. And as I say, it's been a crazy few months in terms of crazy few years in terms of the disrepair claims. So hopefully this webinar will give you an insight as to how to handle them, why there's been such a spike in the claims recently, and also the current trends that the claimant solicitors are adopting. Just to reiterate, the webinar is being recorded, so if you do want to watch back any of this at a later date, you can do. The slides are going to be circulated at the end of the webinar. I do have a glamorous assistant in the background, so if we could move on to the next slide, please, Hannah. On to slide 3, please. So disrepair claims, why are they on the rise? I think you'll agree that certainly disrepair is definitely in the media spotlight. It's high up on the political agenda. We've obviously got the background of the cases of the Grenfell Tower disaster and the tragic case of Awar Bishak. So it's really high up on the political agenda. Another significant factor is there's no fixed costs applicable in the disrepair regime as yet. As I'm sure most of you will be aware, the majority of personal injury claims now are subject to fixed costs, but that's not the case for disrepair claims. So even for the most straightforward cases where there's no liability dispute and the matter's settled relatively quickly, you will still be getting bills for £5,000 to £10,000. And in short, the solicitors are making hay whilst the sun shines. It is also the latest trend for these outfits. So the no-win, no-fee solicitors who made a lot of money out the personal injury claims. I think back kind of 2004, back when I started, that was the big money-making scheme. We've seen holiday sickness claims. We've seen ambulance tracing solicitors. They use these aggressive tactics of door knocking, cold calling, social media campaigns. So they're all combination of factors of why these claims are on the rise. So what do we do? What's my advice to how you handle these? Next slide, please, Hannah. So when you receive a letter of claim, generally the precedent documents that solicitors have just put in a plethora of defects. And sometimes when you read these letters, you think, gosh, this house must be in a real poor state, which often isn't borne out by the expert evidence that you subsequently receive. So when you first get your letter of claim, you've got 20 working days from the receipt of that letter to provide relevant disclosure. The protocol does set out disclosure that you need to provide, but in short, you want to include the tenancy agreement, and it's really important that you also include the tenancy terms and conditions. So it's not just the signed tenancy part of the agreement, it's what the applicable terms are, what you've agreed to do in terms of your maintenance standards, that needs to be provided. You need your repairs log, any contact logs. I know some housing providers have different levels of communication logs, but basically anything that records communication with your tenant does need to be disclosed. Your rent statement, or rather the tenant's rent statement, needs to be included. Gas safety certificates, electrical installation condition reports need to be disclosed, and also any other relevant documentation. So if you've done a stock condition survey, for example, which I suspect you will be now in light of AWAB's law, any previous damp and mold surveys in the course of that specific tenancy. If you've had a previous disrepair claim, that would be disclosable. So basically any documentation relating to that specific tenancy will need to be disclosed. once the letter of claim is received, now this is a bit of a grey area because there is a lot of confusion sometimes over this. The letter of claim will say that you should not undertake any works at the property without prior agreement, which is technically true, but if there are emergency works to undertake, for example, there is an active leak or there is an emergency gas issue, for example, you absolutely should be going in to carry out repairs. It's not just a blanket, well, down tools and don't undertake any works, but any works should be communicated to the other side. So if you're using external solicitors, you need to communicate those works to your solicitors. Or if you're handling the claim in-house, those works need to be communicated directly to the claimant's solicitor. I always try to describe the property as like a crime scene. So the key is that the claimant solicitors want you to preserve the evidence. They don't want you to go in and fix everything and basically turn around and say there's no defects. But if there are emergency defects or hazards that need repairing, you do need to undertake those. So the protocol requires the conditions to be preserved until the parties have had the opportunity to inspect. Obviously, we are going to touch upon Awaab's law later on in the webinar, but what I would say at this stage is that Awaab's law and its provisions do trump the protocol. So once Awaab's law comes in October, if you're getting a complaint of damp and mould, you need to respond to that in accordance with Awaab's law. If a letter of claim subsequently comes in, you should still be undertaking the works as per Awaab's law. In short, Awaab's law trumps the protocol. Next slide, please, Hannah. So once you've provided the disclosure, either if you're handling it in-house or via solicitors, the next step would ordinarily be to instruct an independent expert surveyor. Again, I know a lot of housing providers tend to use in-house surveyors. I have no particular issue with that, but what I would say is the courts tend to favour independent experts. So it's not a case of questioning their ability or their qualifications, it's just purely they're not independent. Some people might argue that claimant appointed experts aren't independent either, given they tend to work on the basis of them, unless they find £1,000 worth of disrepair, they're not getting paid. So I would potentially question their independence anyway, but there we are. I do have a number of clients who do appoint in-house surveyors, and I have to say, you know, they do have success with that as well, mainly in pre-lit settlements. I think if a case became litigated, my preference would be that there'd be an independent report on behalf of the defendant. For those of you who don't know, the experts then prepare what's known as a joint Scott schedule. So this is basically a table which sets out the defects on the left-hand side. The claimant appointed expert will set out his findings and the costing of his repairs. And then our expert or your in-house surveyor would respond to what he found and the cost of the repairs that he recommends. You will tend to see quite significant difference between these. There's a particular firm at the moment and their preferred expert, as it's been recorded, I won't name them, but their expert tends to find around £12,000 to £15,000 worth of disrepair in the property, which usually includes brand new windows, brand new doors, and knock the house down and start again. Whereas our expert may say there's a couple of seals which need replacing around the windows, perhaps a failed double glazing pane, for example. So that's why I really do think it's always a good idea to get your own expert report. So Scott schedule will form predominantly part of your statement of case if the case was to litigate. Next slide, please, Hannah. So the schedule and the works, once provided by the experts, will identify your next steps. So my recommendation would always be to get those works scheduled as soon as possible. or any further investigations have been recommended. For example, if it's a case where there's some cracks which need investigation by structural engineer, get the ball rolling with that, because these things can take time. One common problem I come across with my clients is they may not be liable at the time the letter of claim came in. Say there's minimal notice or no notice whatsoever of these defects prior to the letter of claim. For one reason or another, the works aren't then scheduled or carried out for potentially a year, 18 months later, often due to communication breakdown or just a fault in the system. And then unfortunately, by the time it gets to me, 18 months later, I have to say, well, we're on notice of disrepair for 18 months. So absolutely, it's great once you've got your report, but then we need to follow through and do the works. Another downfall that I do see is that appointments aren't always communicated to the claimant solicitors. They will definitely be saying to their clients, don't let the landlord in, or don't make it easy for the landlord, shall we say. They'll say, make sure you have notice. If the landlord doesn't tell you or us, don't let them in. And then we get into a situation where we have to prove that appointment or appointments were communicated to the tenant. So I always ask that you provide appointments, if I'm acting on your behalf, that you provide appointments to me in advance, so we can have a paper trail of me passing on those appointments to the other side. Often the claimant solicitors will object to allowing works to go ahead on the basis that there is a discrepancy between the findings of the respective experts. So they will say, we're not letting you in because we don't agree your expert's works, or rather, we've advised our tenant not to let you in. There is case law on this. I've just quoted it there for you, Liverpool Mutual Homes and Mensa 2017 case. Where the court actually issued an injunction compelling the tenant to give access. That was a case where access was being refused because they did not agree the works that the expert had recommended. So this is a really important case to throw at the other side if they are refusing access. Obviously, the longer the works are outstanding, the more compensation the claimant may recover, and the more liability may attach if there's a delay. So it's absolutely crucial that you get in and undertake the works, not just from a claim perspective, but also from a conscientious landlord point of view. You don't want, contrary to what the solicitors think, that your tenant's living in disrepair. So it's really important that we get these works done. Next slide, please, Hannah. So here I've broken down really briefly and succinctly the 4 things that a claimant needs to do to establish liability. It is a little bit more complicated than this, but I like to keep things simple, straightforward. And this is it. This is the position in a nutshell. First of all, they need to establish that there's an actionable defect for which the landlord is responsible, which I will get into in the next few slides. Then they have to establish that the landlord, was on notice of the defect, whether directly or by way of constructive notice. So direct notice, I think, is quite self-explanatory. If, for example, the respective experts find actionable damp and mold in the property, and when we look at the communication history, the context history, or the repair log, there is evidence that, yes, indeed, the tenant was reporting damp and mold, then that's direct notice. Constructive notice is more applicable in respect of, for example, external defects. So if the roof's in a poor condition, and that would have been apparent to anyone from the landlord. So it doesn't have to be a surveyor, it can be a gas operative or a housing officer. If that defect should have, would have, I won't break into song, would have been apparent to anyone visiting that property, and then there is a potential to argue constructive notice, but it is a weaker argument for the other side. The third point that they need to establish is that the landlord failed to repair the defect adequately or at all within a reasonable period. So it may be that the landlord has attended and has attempted repairs, but they're saying that the repairs have failed, or they haven't done any repairs. Sometimes you'll have situations where you'll have multiple visits for a leak, for example, and we just don't seem to be able to identify the source, which I don't necessarily consider is unreasonable. If anyone's had a leak in their property, it's not always an obvious source. You know it's coming from somewhere. But if we can show that we've taken reasonable steps, then you've still potentially got a defence there. Then, even if the tenant has established 1, 2, 3, they still have to show that they've suffered a loss, or that they suffered real distress and inconvenience as a result of that disrepair. So again, we will argue more often than not, if there is an actionable defect to the external brickwork, so there is some missing pointing, or there's a few tiles that have slipped on the roof, they are actionable, yes. Were we on notice? Let's say, for example, you were, the tenant had complained about these, or someone internally had reported them. We'd failed to repair it in time, so it's been sat there for, say, a year. But let's say there's no internal consequence. So yes, there's some missing pointing, but there's no damp coming through as a result, or there's no water ingress into the loft. I would still argue that the tenant hasn't suffered a real loss as a result of that disrepair. A lot of claimant solicitors are of the view disrepair equals liability. And it's not as simple as that, and we are successful on that argument on numerous occasions. Next slide, please, Hannah. So just turning to actionability in terms of the defects. Now, again, I tend to lean heavily on the expert surveyors in this regard, which is why, again, it is preferable sometimes to get an independent report. I'm not a surveyor. I'm not a landlord either. I'm a lawyer. So in terms of the nature of defects, etc., yes, I do understand quite a lot of the terminology because of the nature of what I do, but I will still revert to a surveyor in terms of interpreting Section 11, etc., etc., to what relates to the structure and the exterior. So Section 11 is the first and foremost that the surveyors will comment on. The duty under Section 11, landlord and tenant, is only owed to the tenant, so it isn't owed to non-tenants. So if claimant, well, for example, if the claimant isn't named on the tenancy, then they've got no claim under the Landlord and Tenant Act 1985. It does require for liability to attach, notice is required. So the tenant has to report these defects, even if the landlord has a right of access to the premises, which will be applicable in most standard tenancies. The general rule is that a covenant to keep premises in repair obliges the covenantor to keep them in repair at all times. So there is a breach of the obligation as soon as a defect occurs. You do still have the grounds of denial, which I will address later on. So this is Section 11. Next slide, please, Hannah. We then move on to Section 4 of the Defective Premises Act 1972. This does extend to other individuals other than the tenant. So this can be named household members, for example. So you'll see a lot of injury claims are pursued under Section 4, the DPA as well. So where the premises are let under a tenancy, which puts on the landlord an obligation to the tenant for maintenance or repair of the premises, the landlord owes to all persons who might reasonably be expected to be affected by the defects in the state of the premises a duty of care, a duty to take such care as is reasonable in all the circumstances to see that they are reasonably safe. So it's not to ensure they're safe, but it's reasonably safe. So again, this can be misinterpreted or misapplied by claimant lawyers. So they are reasonably safe from personal injury or from damage to their property caused by a relevant defect. So in this case, it is where constructive notice comes in, so that either we were on direct notice or in all the circumstances, the landlord ought to have known of the relevant defect. So this will often apply in terms of front paths, for example, or external defects. Next slide, please, Hannah. So this just sets out some of the key. It's a good summary page in terms of the Defective Premises Act. So it imposes a wider duty than Section 11, especially given it's not just a tenant. It covers passerbys, visitors, and trespassers to the premises. Although I'm not suggesting a passerby can claim for disrepair, but just generally in terms of what the Act covers. Actual notice isn't necessary. There is potential liability if the landlord ought to have known about the defect, and also it's not just confined to the structure, which is the case with Section 11 LTA, and the landlord is under a duty to ensure that no defects exist, but there are still grounds for denial. Next slide, please, Hannah. Nuisance as well, we're definitely seeing, and I will come on to current trends that we're seeing in the market, but nuisance is definitely something that's on the increase in terms of the claims. I have recently been dealing with several claims that have been brought against my landlord clients under the EPA Environmental Protection Act, which are not civil claims. These are criminal proceedings that are heard in the magistrates' court and can attract significant fines, significant damages are payable, and as always, significant costs. So I'm sure you do all have systems in place should you receive these types of claims, but if not, if you do receive a notice of intended prosecution, please do take it seriously. It's much easier for us to handle if you involve us from the outset. The kind of nuisances we're seeing is your rodent infestations, or even flea infestations, bed bugs, that kind of thing. These are infestations in common parts, or for example, water leaks from neighbouring premises. So we definitely see an increase on these claims. And these aren't instead of a disrepair claim. It could be that the claim starts as an EPA, and you'll have the criminal proceedings. And then they're perfectly entitled to bring a civil action under the disrepair protocol as well. So it may hit you with a double whammy. So please do take those seriously if you receive any of those claims. We do have a special regulatory team at Forbes as well who can specialise in those claims if we need their expertise as well. Next slide, please, Hannah. And then we do have I'm sure you're all very familiar with this act now. This is the Homes Fitness for Human Habitation Act 2018. This brought in amendments to the Landlord and Tenant Act in 1985. It first came into force in 2019, which doesn't seem like, well, it seems like yesterday, should I say. But yes, it was 20th March 2019 that it applied to newly granted tenancies, and then as of the 20th of March 2020, so unbelievably over 5 years ago now, it was applied to all tenancies whenever granted. So this requires a property to be fit for human habitation. We're just now starting to see case law coming through as to what amounts or what the judges consider as being unfit for human habitation. Because I would definitely say the vast majority of claimant reports that come through say that properties are unfit for human habitation. And I sometimes look at these properties and I think it's actually better condition than my own. But it is ultimately for the judge to determine based on the expert evidence. But if your own expert is describing the property as unfit for human habitation, then clearly you need to take urgent steps to remedy any of those issues. If that means decanting your tenants on a temporary basis, then so be it. Next slide, please, Hannah. So this just goes into a bit more detail, thanks, Hannah, of what, I won't read it out. As I say, you're going to get copies of these slides, but Section 9 is the relevant section, and Section 10 as well. So it just explains that the landlord basically covenants to keep the property as fit for human habitation at the time the lease is granted or otherwise, and that it will remain fit for human habitation during the terms of those lease. It does also apply in respect of common parts. Next slide, please, Hannah. There we go. So these are just a few of the examples of what would deem a property unfit for habitation if there are any serious defects of the repair, stability, freedom from damp, which is obviously the headline case or the headlines at the moment, internal arrangement, natural lighting, ventilation, water supply, drainage and sanitary conveniences, and facilities for preparation and cooking of food. As I say, we're just starting to see the cases coming through now to litigation where judges are being asked to determine whether it's unfit for human habitation. So perhaps we'll do an updated webinar in due course, just focusing on those decisions. So at the end of these slides, I have put together a quite useful table. Well, I've not put it together, but there's a useful table of the different kinds of hazards that you need to be looking at in terms of that act. Next slide, please, Hannah. So you should all, I hope, be aware of Awab's law. This is approaching quickly. It's coming into force in October. For those of you who don't know, this followed the tragic death of Awab Ishak, who was residing in damp and mold conditions. It was actually subject to a disrepair claim at the time, and there was a delay undertaking the works, and sadly he passed away from mold related illness during that time. So this is why I always stress to my clients, I'm not saying disregard the protocol, but put your tenants first. And if they're living in damp and mold conditions, then that's not good enough, and we need to put that right. So following his tragic death, the Housing Ombudsman published a report, which in terms of damp and mold, and subsequently it's going to be other hazards, it puts the onus on landlords to take a proactive approach and to refrain from blaming tenant lifestyle. I'm sure we've all used the phrase tenant lifestyle in the past. And that's not to say that we can no longer refer to habits. So if certain actions are taken, such as drying clothes inside, etc., then we still have to advise tenants what they can do to mitigate those conditions. But it's not good enough for us to just say it's your fault and leave them in those conditions. We have to take, or the landlord has to take, proactive steps to assist them. So just hot off the press, last month we did have the long-awaited timescales for Awab's law. So as I mentioned, phase 1 of Awab's law will commence in October 25. That sets out the requirements for social landlords when faced with reports of damp and mould. We are expecting phases 2 and 3, which will extend to other hazards to be implemented in 2026 and 2027. Understandably, it is being phased because damp and mold is clearly going to have a significant impact on you in terms of responding to those timescales. So it does give us a bit of breathing space, and obviously damp and mold are probably deemed the most serious hazards. So tenant safety must now be paramount, with landlords having a duty to ensure homes remain fit for human habitation and free from category 1 hazards, i.e. damp and mold. Next slide, please, Hannah. So in terms of the timescales, for those of you who don't already know or are responsible for passing it on, when you receive a report of damp and mold as of October, inspections must now be carried out within 10 working days. Repairs must begin within 5 working days of confirming the existence of a health-related hazard. If works cannot begin within 5 days, so if there is a structural complexity, i.e. you need to install scaffolding or there's other issues, they must start within 12 weeks. Tenants must receive a written summary within 3 working days of investigation, to set out their findings, the next steps, and the estimated time scale. So almost like a stop schedule or a schedule of works, and setting out your timetable, etc. So this, I appreciate, having worked closely with housing associations and providers for many years. I know this is going to be a big ask to meet those timeframes. But I know you've all been working incredibly hard to get procedures in place to try your best to meet these. In terms of emergencies, so your active leaks or anything else that would ordinarily be deemed an emergency, they still need to be attended to within 24 hours to assess and make safe. I have just added the link there to Awaab's Law, the draft guidance for social landlords, for anyone who hasn't accessed it already, but this is just for ease of reference. So you've got that link there within this slide. Next slide, please, Hannah. So just going back to the protocol for claims that have been pursued under the protocol, and just to reiterate what I said earlier on, Awaab's Law definitely trumps the protocol. So if you were getting internal reports of damp and mould, please respond to them in accordance with Awaab's Law as of October, or it might be that you're already following those timescales. So grounds for denying liability for disrepair claims brought under the protocol. The first one is the easiest one, that the defect does not exist. There is nothing I like more than a nil defects report from my expert surveyor. Doesn't happen often because there is usually something, even if it's trivial. But a nil defects report is my favourite, and I'm sure a lot of my clients who may be on this call would agree. So that's straightforward. If it's a nil defects report, then you can simply respond and say, given the content of this report, liability is denied. We have no offers of compensation to make. The next ground would be that the defect is not within the express or implied repairing obligations. So this probably applies, the easiest explanation would be, for example, fencing. If fencing isn't something that's provided for under the terms of the tenancy, but the tenant, for example, has installed fencing, or the previous tenant installed fencing, and that fencing's blown down, and the claimant's experts contending for new fencing to be installed around the boundary for £5,000–6,000, but you say, well, we don't provide fencing, then I would argue, if indeed your tenancy agreement confirms that, that is not under your repairing obligation. You'll also see disputes between experts, for example, floor coverings. Sometimes tenant expert will contend for new vinyl throughout, or new laminate flooring throughout, and the defendant expert will often say the floor covering isn't something that we are obliged to replace under the terms of the tenancy. So it does depend on the terms of the tenancy, hence why I said it's really important that you do provide the terms and conditions of the tenancy agreement. Another ground for denying is one that I've touched upon already. So the defect is so minor that the tenant cannot have suffered any real distress or inconvenience. So, for example, roof defects, missing mortar where there's no internal consequence, or even like a little bit of mold around the window reveal. You just expect the tenant to wipe that up themselves. It's not, assuming it's not linked to a structural defect. Another grounds for denial is lack of access despite reasonable attempts. So even if we have a history of damp and mold being reported, I keep going back to the example of damp and mold, but roof defects or missing kitchen doors or that kind of thing, if they're not letting us in to do the works and you can show that reasonable attempts have been made, that's why it's really important that training is given to even the call centre or the contact centre staff as well. They need to get accurate logs of what's being reported and attempts to make appointments, etc. And so, yeah, that would be another ground for denial if the tenant wasn't allowing access. Another straightforward ground is lack of actual notice. So the number of times we'll get claims where they say they've been reporting defects multiple times, 10, 20 times over 5 years. But when you look at the repairs history, it's just standard gas, gas safety checks, lost the key or locked the key out, etc. Nothing about the defects that are now being alleged. So we would straight away deny on the basis of notice. In that sense as well, we would also argue that the defects haven't caused real distress and inconvenience if the tenant's not bothered to report them. So it works two ways, that defence. And also, and again, this comes back to the tenant lifestyle or not tenant lifestyle, but the tenant is still expected to behave in a tenant-like manner. So if you see defects, a lot of the time we see impact damage to internal doors or to walls where there's clearly been, it's not normal wear and tear to have a hole in your plasterboard, or defects to the door, or if pets, for example, have damaged the walls or doors, then I wouldn't be recommending that you accept liability. Usually you'd need something in your expert report to support that contention. So yes, you still expect your tenants to behave in a tenant-like manner, whatever that may be. Next slide, please, Hannah. So just in terms of the current trends in disrepair claims, as I mentioned, we're definitely seeing an increase in the nuisance type claims. So pest infestations such as fleas, bed bugs, rats, mice, in common parts, or water leaks from neighbouring properties, for example, in a block of flats rather. There is potential for personal injury claims to arise from these. I know a colleague of mine, Elizabeth Bauer, she's recently dealt with a rat infestation case, which was also being linked with, I think, Wheels disease. She gets all the good cases, does Liz. So we're definitely seeing an increase in those types of claims. That's something that I will come on to as well in terms of the injury claims in a few slides' time. Next slide, please, Hannah. We're also seeing an increase in claims being brought under the Human Rights Act and the Equality Act. Again, I have a colleague who specialises in these cases, David Mayer. So all social housing providers, as I'm sure you're aware, have a duty to carry out their function in compliance with the Human Rights Act. Article 8 is the key article, which includes the right to respect for a home, and there should be no interference by a public body. You do not have to provide a right to have a home of a certain quality, but the courts recognise that where the conditions are so bad, it could interfere with a tenant's rights under Article 8. Next slide, please. I must admit, I will breeze over this section a little bit because it's not what I specialise in. But just to assure you, we do have people who do know what they're talking about in this area. So we're definitely seeing an increase of these claims. Sorry, next slide. That seems to be the same slide again, doesn't it? Yes, it provides a right to enjoys one's existing home peacefully. Public authorities should not prevent anyone from entering or living in their home without a very good reason. This could be infringed if a person is forced to leave their home due to poor conditions. So we do sometimes see cases where a tenant will say, the letter of claim will say, they're no longer living there because of the conditions. They've moved back home with family members, etc. Say there's been a leak and a collapsed ceiling, and the landlord's just taken too long to repair it, for example. So potentially they could have a claim under Article 8 of the Human Rights Act. And there can also be potential injury claims arising from the same. Next slide, please. We're also seeing an increase in claims brought under the Equality Act. So whilst the property may not be in disrepair or defective for your non-disabled tenant, it may be inadequate for those who do have a disability. those with disabilities can make requests for adaptations regarding common parts, although there's not currently a legal duty for you to make reasonable adjustments to do so. But I suggest you keep in close consultation with your adaptations team in those scenarios. Next slide, please, Hannah. Just going back to the original point that we're definitely seeing an increase in these no win, no fee cases, but also the PI hybrids. Just in the last week, I think I personally received 4 cases which are brought for personal injury, well, psychological harm or exacerbated asthma from the living conditions. So there is no disrepair element to the claim. It's purely bringing a personal injury claim based on the disrepair. This is definitely an emerging area of law. It's something that we are in consultation with FOIL about, and I know we're definitely keeping a close eye on it. We need to see how these cases turn out at court. So it might be that we run a few of these cases and see how the court approaches them. Because it all comes down to foreseeability of injury when we're talking about a psychological condition. So if a claimant has suffered from living conditions which pose a reasonably foreseeable risk of injury, and as a result of that anxiety and fear, they've then developed, and this is a key bit, a diagnosable condition, it's open to argue that they are a primary victim, and then they potentially recover damages for the same. As I say, it's yet to be tested in the courts. Matrix law, I think the matrix solicitors or matrix law, they're the ones that are bringing these cases. So I suspect we're going to see a lot more cases in this field. I think damp and mold would be more difficult to prove. So i.e. psychiatric injury arising from living in damp and mold conditions where they have developed a recognizable condition. So PTSD, depression. So not just that they're a bit upset or distressed, it has to be a recognizable psychiatric condition. In terms of rat infestations, for example, it's perhaps more foreseeable that they would suffer a physical injury as a result of rat infestation. So you can see how the link to them suffering a psychiatric injury could be made. The key, as with many personal injury claims, is going to be the medical records and the quality of the expert evidence, but we're definitely seeing an emergence of those claims. And it's just another way for the solicitors, unfortunately, to make money, not us, I should add. Next slide, please, Hannah. Oh, yes, and these are just the hazards I mentioned earlier on under the Homes Fitness for Human Habitation. I've just set out the different hazards. And just as a reference point, really, I think that's the next 2 slides from memory. Yeah, so that's just something for you to refer to. And I think that is probably the end. Yes, there's a lovely picture of me to signal the end of this presentation. So I am open to any questions. We have a bit of time, so if anyone does have any burning questions, then please feel free. I assume you can put your Hannah will correct me if I'm wrong. If anyone's got any questions, I think you can put them in the chat function. I will assume, unless someone is drafting a really long question, I will assume there are no immediate. Oh, no, someone's got the hand up. Right. You mentioned Section 11 only relates to tenants. Doesn't the protocol allow for other residents to claim too? Um, Donna, I would when a letter of claim comes in, you can only bring a claim for disrepair if you are the named tenant. So if it's a co-tenancy, then a tenant could both tenants could claim. But if it's, for example, just a household member who's not on the tenancy agreement, then I wouldn't say they could bring a claim under the disrepair protocol. Of course, they could bring an injury claim, but not under Section 11. If a claim letter says home is unfit for human habitation, does this give us grounds to go in ASP thinking of preserving the crime scene? In that scenario, Vicky, it may be worth depending on your resources. It may be that you get in there ASAP to do an internal survey. If when you go in there and discover that it is in an appalling state and you would deem it unfit for human habitation, then I would say yes, with our Web's law cap on, you need to fix those ASAP. As long as you keep a log of what you're going to do, and probably the costs are the same, because that's what the claimant solicitors will want to know. How much is it going to cost to repair, because that's how they will calculate their client's damages. So if when you go in there, if you have the resources to do that, and actually the property isn't in that bad a state, and there's nothing that's deemed an emergency or unfit, then you can revert to you could still get your independent expert evidence if that's how you do it at your organisation. I hope that helps. More of a comment. Hi, Dawn. Matrix advertisers running personal injury cases along with disrepair. Yes, I think they are doing the disrepair cases, but the particular cases I've received are just for the psychiatric injury. The protocol, the housing conditions protocol, does allow for injury claims to be pursued under the disrepair protocol, but that is usually your kind of low value ones where just a GP letter will support it. So very much a low level, short term exacerbation of say a one-off chest infection, or a very short period of exacerbation to asthma. If it's over and above that, where they're actually going to want to get a report from a respiratory expert. I know I've seen a case recently where the tenant has quite a serious respiratory condition. He's actually unrepresented, so it's a medical report that's been obtained by the insurer, and it's worth quite a lot of money. So that wouldn't be pursued under the disrepair protocol. You would expect that to be pursued under the usual injury protocols. I hope that I know it's a comment, but I hope that that makes sense. Any others? As I say, my contact details are on the slide. So if anyone does want to contact me, I'm always open to chat about my favourite subject of disrepair. If you have any specific questions about your particular scenario, then please do get in touch. And as I say, we do have specialists in numerous areas that can help you if I'm not the person for you. Okay, right. Unless anyone's got anything to add, I shall bid you good morning. Thank you.